CAHAI is currently elaborating the main elements of a legal framework on design, development and application of artificial intelligence in line with the Council of Europe standards on human rights, democracy and rule of law. The multi-stakeholder consultations were organized with a view to helping the CAHAI Legal Framework Group in its ongoing work on preparation of such elements, and it was designed as a non-binding support tool in this regard. The consultation process and the results have allowed us to register areas of consensus as well as dissent among the respondents. And the respondents include governments, public administrations, international organizations, business, civil society, academia, and the internet technical community.
The 47 governments of the Council of Europe are working on artificial intelligence. They decided that it should not be just governments to discuss, but that other stakeholders such as industry, civil society, academia should also have a say. Therefore, a multi-stakeholder consultation was just concluded. Over 260 replies were received from many parts of the world. They include responses from government agencies, but also from industry and civil society and academia. There is a consensus emerging amongst the participants, namely that the current legal rules that apply to the design, application and use of artificial intelligence are not sufficient. Why not? Because there are risks. Artificial intelligence brings enormous benefits, but clearly, as emerged from this multi-stakeholder consultation, it also carries risks. These risks are particularly seen in the fields of justice, law enforcement and national security. It is also felt amongst the various stakeholders that the legal frameworks that apply current international treaties, national legislation and self-regulation, ethical charters for instance, are not sufficient. They are helpful, but not sufficient to mitigate the risks. Especially for high-risk applications, binding international rules, specific rules, are considered necessary. What will now happen is our experts will analyze and take into account the results of this multi-stakeholder consultation. They will also take into account, of course, and in fact their decisions will be based on the results of a recent ministerial meeting, Ministers of Foreign Affairs, which instructed the committee to identify the elements of a possible binding legal framework, as we call it, that is a treaty, and non-binding legal regulations that can be recommendations, guidelines. There will still be a lot of discussion necessary, because the consensus on what has to be done will now have to be translated into how it is going to be done. We have until the end of the year to present to our governments a final report on what could be the particular provisions of a future treaty. In doing so, the various stakeholders that replied to our questionnaires will also be involved in the discussions. So it will continue to be a multi-stakeholder dialogue. We have 5 months left. There'll be 5 intensive months, and by the end of the year I'm confident we'll have a set of clear proposals to our governments on how to proceed with legal regulation of the design, implementation of artificial intelligence to ensure that it respects human rights, rule of law and democracy.
The consultation has registered a broad consensus as regards the need for binding regulation of technologies that present high risks of human rights violations, regardless of the level of probability. It is clear from the responses to the questionnaire that public authorities and states are expected to implement binding regulation, and that self-regulation or soft regulation through ethical charters are not enough when human rights, democracy, and the rule of law are at stake. The consultation has also clearly indicated that even existing binding legal instruments are not sufficient to regulate AI systems, according to 74% of respondents from all sectors, including government organizations. Also, it has emerged clearly that respect for human dignity, privacy, and data protection, as well as non-discrimination, should have a prominent place in the Council of Europe's future legal framework on AI. In that respect, I would like to recall that the elaboration of this legal framework is currently one of the main priorities for the Council of Europe.
As you may know, the CAHAI-LFG is preparing the elements of a future legal framework on artificial intelligence that touch on many of the topics covered by the consultation. Interestingly, the consultation also confirmed the difficulty of finding a consensus on certain thorny issues, such as the limits that must be placed on the use of disruptive technologies. Think of facial recognition. These are issues on which there's also much debate within the LFG. However, the consultation also revealed clear points of convergence amongst the stakeholders. We know, for instance, that the respondents find it important to challenge a decision made by an AI system, to have access to an effective remedy, to inform individuals when the use of AI affects them personally, or when AI systems are used in decision-making systems. They also prefer human review of an algorithmic decision, especially in sensitive fields like justice. The consultation also confirmed the usefulness of compliance mechanisms to prevent and mitigate risks to human rights, rule of law, and democracy. All these are issues that we're currently exploring in the CAHAI-LFG work. And I look forward to updating you on the progress made on the occasion of the CAHAI plenary in December 2021, when our final deliverable will be examined by the CAHAI.